In the wake of that latest criminal indictment against Donald Trump, people are wondering if the 14th Amendment could keep the former president from taking office again.
Casey Decker with our National Verified team's been talking to constitutional law experts to get some clarity.
Former President Donald Trump is now facing federal charges related to his efforts to overturn the results of the 2020 election. And with this latest indictment comes questions about how these new charges could impact his run to reclaim the White House. Verified viewer David emailed us to ask if the 14th Amendment could potentially keep Trump from serving in office. Section 3 of the amendment is commonly known as the Insurrection Clause, and it gives Congress the power to ban public officials from holding office if they, quote, have engaged in insurrection or rebellion against the U.S. Constitution. So let's verify. Does the Insurrection Clause of the 14th Amendment apply to former President Trump? Our sources are the 14th Amendment, Supreme Court Chief Justice John Roberts, and 2 constitutional law experts. This claim needs context. Our experts say it's an untested legal gray area. The clause has never been invoked for a president, and there are several things that would need to be clarified. First, the Supreme Court would need to rule on whether the clause can be applied to a president. Section 3 lists the public officials who can be banned from office if they engage in insurrection. Members of Congress, members of state legislatures, and officers of the United States are included. The president isn't, but could he be considered an officer? Some legal experts argue that Chief Justice Roberts said the answer is no when he issued an opinion in a different case in 2010. In that opinion, Roberts mentioned that officers of the United States are by definition appointed, not elected. But he didn't specifically say that means the president can't be considered an officer.
For purposes of Section 3 of Article 14, there is no certified answer by the United States Supreme Court for this question.
Second, the 14th Amendment doesn't say how whether someone engaged in insurrection is determined. In the past, criminal convictions, civil actions, and even acts of Congress have served as proof. So in theory, a judge or Congress would have to explicitly state that Trump is ineligible for office under the Insurrection Clause. And then the Supreme Court would have to uphold that decision. But even if that happens, another part of the amendment says Congress can exempt someone from disqualification and let them take office with a 2/3 vote of each house. With your Verify, I'm Casey Decker.